Hello and welcome to Big Deal. I'm Nisha Poddar. Now, a year has passed since India passed its first ever Privacy Act, but the rules are yet to be notified. But the wait may be finally over. A few days back, the IT Minister Ashwini Vaishnav ensured that the rules for the Digital Personal Data Protection Act, also called as DPDP Act, will be issued soon for public consultation. Now, the rules are expected to be out within the next 20 days and will be implemented in this particular financial year. Now, to understand the implications of the rules and what should be included in the rules and the way forward, we are now joined by an extreme expert panel who have been tirelessly working on this particular subject. Let me welcome on CNBC-TV18 Senior Advocate N.S. Nappinai, Medianama's Nikhil Pahwa and MeITY's former Senior Director Rakesh Maheshwari. Lady and gentlemen, thank you so much for joining us right here on CNBC-TV18. Now, beginning with you and the lawyer's take, ma'am, what do you think of the rules and how important are they at this particular point? The government has procrastinated for too long and things have changed. How critical is it at the current moment?
Well, you need the rules for the Act to be implemented at this juncture. If you see the way the law has evolved in India, the first draft was submitted by the Sri Krishna Committee, which was vested with the scope of engagement to evaluate what is the contours of a privacy law for India. Then you had the 2019 Act, which was fairly lengthy. And then you had a very bare bones kind of draft, which you have now. And you need the rules to actually supplement what you have in the law to be able to enforce it. So that's a general input. To get more specific, so you need, for instance, you have a privacy process that has been established under the DPDP Act. So you have data fiduciaries who are going to be collecting your data, data processors. You are the data principal, that's the user who's sharing their data. You have consent frameworks and accountability frameworks. Now, these are just words. How do you enforce them? How do you implement them? So that granularity always comes from rules. So when you asked about the time frame, it is true that the rules are much delayed, and we are hoping that we would get a fairly robust draft now, which will ensure speedy implementation. And what is it that we can hope for? We will need something that would give flesh out the bare bones draft, will give strength to the system that is proposed to be established, will ensure strong data protection of individuals, and the balancing act here, which is what every data protection law brings in, is enabling industry. A law is not meant only to protect users and to stifle innovation or industry. It is meant to bring about this balance and enable industry too. Enabling without ensuring that it will violate individual rights. Now, we have to wait and see whether the rules are going to be able to play out this balancing act.
Right. So balancing act is going to be required, and there is immediacy in these rules coming out because the act was passed by the Parliament last year. Now, Rakesh Maheshwari, you have been part of the ministry when this particular bill was in formulation. What was the government's thinking, and how do you think this particular act stands in the current circumstances in achieving its goals?
Yeah, so thanks a lot. And as conveyed by Madam Nappinai ji, that the Act in the present form and the intent as it was all throughout since 2017 when the expert committee was constituted was that the rights of the citizens have to be protected, the privacy rights which have been granted by the Honorable Supreme Court, while also the business must continue to be enabled. So that was the founding principles, that both these things should continue to be there. And because the present IT Act, though it does cover privacy, the sensitive protection of sensitive personal data, it is in no way a comprehensive act and the rules therein. So this act, to that an extent, brings in the whole comprehensiveness, including the protection of the data of the individual, which is the data principle of the data fiduciary obligations of the data fiduciaries, maybe data related to the children, how exactly is what security controls need to be there, how exactly the law shall be enforced, which is through the Data Protection Board. So all those things the Act has brought in, and the Act in a way requires consent to be there. Consent framework has been talked about, which should be presented to the user in a language which the user understands. So that means a lot of effort in terms of making it user friendly, while also, of course, proportional to the risks and the size of the industry. And simultaneously, government has also been brought in the purview of the Act.
Yes, government has also been.
Fair. Yeah.
Yes, yes. So many important points there, Rakesh, Maheshwari. Let me take it to Nikhil Pahwa. Nikhil, of course, fundamental right of privacy, that's what we are granted. But how critical are these rules in exercising that fundamental right?
Thanks, Nisha. Look, as far as I'm concerned, we actually don't have a privacy law yet, because the law said that that different parts of that law will only be activated once these rules come out. So I think it's fairly shameful that a year after the act was passed, it still hasn't been actioned, and we waited all this while for rules to make it active. The government should have done this sooner, even if it should have at least had some parts of the bill activated through the rules till now. The other thing, I want to just disagree with some of my panelists on some points. Like if you look at the various drafts of the bill, it was the Sri Krishna draft that Nappinai mentioned, which was the strongest of them all. Bit by bit, the protections provided to citizens have actually been whittled down. And one of the things that this law battled against from the very beginning was that the intention of the government was actually to not have a privacy law. They went to the Supreme Court and argued that privacy isn't a fundamental right. They were directed by the court to basically put together a law to enforce the fundamental right to privacy through a law, especially when it comes to private companies. And subsequently, even in the Sri Krishna draft, there was a battle between enabling a data economy versus protecting rights. So the bill actually lacks balance in terms of protecting rights, and especially with respect to the government. For example, there is no surveillance reform that's happened through this particular law. The government can still access citizens' data held by private companies. So in effect, the apps and the services that we use, the government has a free rein in terms of accessing that data for purposes of national security, and national security is still not defined under law. So I don't think it does enough to protect our rights. And in that sense, the bill already, or the law already, is a failure to begin with. The other instance where it does not protect our rights is it doesn't give us the right to go to a court directly. We have to actually file a complaint with the Data Protection Board, go through an entire process instead of trying to enforce a law by going to court. But the board itself can only adjudicate on matters of complaints, and it doesn't have any rule-making powers. If you look at data protection authorities across the world, a majority of liberal democracies actually have that power, have given independence and power to the board to protect citizens' rights. In this case, the board doesn't have these aspects, right? So I don't think this data protection law, even after the rules come out, will do enough. And it's a failure on the part of the government from a citizens' rights perspective. But I don't think that was their intent from the very beginning in terms of protecting protecting citizens' rights. If the rules don't come out for another year, I would not be surprised, to be honest, because I don't think it's the intention of the government to really restrict, data collection and violation of our privacy, to be honest.
All right, many questions raised and fair criticism there by Nikhil. Nappinai, you want to counter some of those? As a lawyer, you must be itching to.
Well, we also sometimes agree, we don't always contradict. So I had a couple of points I wanted to add to what Nikhil said and also qualify some of the others. The first and foremost, Nisha, you must have heard me on this earlier too. My biggest grouse with respect to the DPDP Act has been the lack of understanding of what data protection is supposed to be about. Any collection of data is predicated on a consent framework to a large extent, particularly when you're talking about sharing data on platforms, social media or online platforms. So your contract on that platform decides how your data will be utilized. So there is a level of voluntary submission there, but it is also subject to the contractual terms there. A data protection law is meant to ensure that these contractual terms will not be unconscionable, and that even where consent is given by somebody, they would still have the right to withdraw that consent or seek for modification of the data where they show that it is incorrect, etc. Interestingly, in limiting the scope of the DPDP Act, a new provision has been introduced there, which was not there in the two earlier drafts, which says that if you have submitted your data voluntarily, then you do not have the protections under the DPDP Act. It's beyond the scope of DPDP Act. And furthermore, interestingly, the illustration that is given is that, for instance, if you share personal data voluntarily on a social media platform. So, right. The way I understand it is, if you're going to share voluntarily on a social media platform, it is subject to the contractual terms there, and those terms are meant to be conscionable. If it is unconscionable and against the terms of the DPDP Act, it should have been struck down, and that's the right we should have been given, not keeping it out of the DPDP Act. This is just one aspect. There are many others. We have already, Nikhil touched upon the exemptions aspect. Now that's, it's not like a black and white situation. There are certain exemptions that a government or a governance will need. For instance, law enforcement. You can't expect police to investigate and wait for them to seek consent of an individual. But the checks and balances in terms of a privacy law, and here it is actually captured in your criminal laws, is that you have to follow due process when you are seeking the data of individuals. So I would say that you should paint all the exceptions with the same brush. You will have to evaluate them individually.
Right. So many points there and a lot of technicalities which the government also needs to address while formulating these rules. We'll slip into a short breather. Hold on to your thoughts. There are many more developments, and also National Commission for Protection of Child Rights has also recently suggested some recommendations for these rules when it comes to the data regarding children and their internet usage. We'll talk about that and the business impact of this protection as well after a very short break. Stay tuned to Big Deal.